Welcome to Vermontitude, a collaborative effort between Great Eastern Radio, the Brattleboro Reformer, and BCTV to bring you the stories behind the stories on the topics you want to learn more about. Because there's always more, so there'll always be Vermontitude. Hosted by me, Peter Fish Case. Welcome to Vermontitude. New episodes drop every Tuesday and can be found by going to vermontitude.com, reformer.com, brattleboro.tv, and locally on Comcast Channel 1078. We come to you from our studios at the Innovation Box on Flat Street. I'm Peter Fish Case, and each week I cover the topics that are of concern to Windham County and the towns that reside within its borders. Joining us today on Vermontitude, Windham County State's Attorney Tracy Schreiber. Welcome.
Good morning. Thanks for having me.
All right. So here's what we're going to be talking about today. We're going to be talking about released on conditions. Now, let me just explain that released on conditions are just what they sound like. Orders or conditions that a judge apply so that you can be released from custody while your case is pending. This means that right at the start of your case, you can be put in jail unless you follow the rules that the court sets. We know that there are exceptions to this. Tracy, can you tell me why this doesn't seem to be enforced? Where is the breakdown happening?
So just to talk a little bit about conditions of release and the law that applies to them here in Vermont is that every person who comes into court, with a few exceptions, as you said, is presumed to be released without conditions. And my office makes an argument about what conditions or bail is appropriate to get someone released. So every arraignment that happens in the criminal division, we are there asking for certain things. It's a rare exception that we are asking for no conditions or no bail, but that does happen. And it's also the rare exception that we're asking someone to be held without any bail. Those are very, very exceptional cases. So the majority of people who come into court, we're either asking that the court impose certain conditions, like come to court when you're told to, tell your attorney what the address is that you're living at, and don't commit any other crimes. Sometimes we're asking for bail, and I do want to talk about what the purpose of bail is, but almost everyone who walks out of the criminal division has conditions of release. There's no one monitoring those conditions of release. We're relying on people to have a court order in their back pocket and do what the court tells them to do. And as we know, there are people who don't do that. All
right. So here's, we see it often. I don't know if you have kids call them metrics on this. Like, how many times does this fail?
I don't have
a number
That's of that. Fair. I mean, it's from experience. It depends on the case. It depends on the person. But again, you're being released promising that you'll do what the court told you to do. And some people, obviously, we know, are better at doing that than others. And some people are better at breaking those conditions and not getting caught than others. But it's not unusual to have someone back in court violating their conditions.
All right. So are there cases where conditions of release work, and or is this just bad across the board? I mean, I know you sort of alluded to that in your response there, but.
Well, I think sometimes there are conditions of release that work. It depends, again, on the case, and it depends greatly on the person. When we're talking about crimes of interpersonal violence, again, it depends on the person, but those are more frequently conditions that would be abided by. If you're giving someone a curfew condition, for example, that's the one I see really pretty frequently violated. That's something that's hard for a lot of folks to abide by, and it's easy to get away with breaking.
Yeah, well, I understand that. It does. The curfew one is probably put in place because, well, once I often say once the sun goes down, sometimes the idiot goes up. So you didn't say that. I did. Let's talk about bail for a second, because I got a quick lesson from a friend of mine a little bit about how bail works. And I have to admit, I don't think I understood it completely. So can you shine a light on that?
Absolutely. So something that's often misunderstood, quite understandably, is that bail is only imposed secure someone's appearance in court.
Okay.
Now, when we think about it, we think, well, shouldn't somebody have a high bail if they are dangerous or they're committing a large number of crimes? That's not really how bail is imposed. Bail is solely imposed to make sure someone comes to court. And the legislature has enacted laws that put limits on the amount of bail you can impose on particular crimes as well.
Oh, interesting. Really?
Yes.
Okay.
So there are a majority of misdemeanor cases where the legislature has created a law that you can't impose more than $200 bail for that case. And you're only going to be imposing bail if you think the person is not going to come to court.
Right.
It's not that you think the person is not going to abide by your conditions. It's not that you think the person is dangerous. The judge has to make the decision, will this person come to court? And that's when the judge decides whether or not to impose bail.
So give me an example, if you can. What is the crime that would constitute a $200 bail?
There's lots of them. Simple assault, unlawful trespass, unlawful mischief.
Only a $200.
Only $200
assault.
Maximum bail. Yes.
Interesting.
Yes.
I can remember when I was in college, we drove to California. We got pulled over in New Mexico for doing 95 miles an hour in what was then a 55-mile-an-hour zone, and we're given a $15 ticket. And I remember we all laughed and said, that's completely worth it. There's no reason to slow down here. So is this the same kind of theory here?
Well, our legislature changed the law a few years ago and indicated that any crime that's available for expungement or sealing can only be $200 maximum bail. Folks should be aware that the legislature is also considering doing away completely with cash bail. So if that's something that speaks to you, that you have an opinion on, you should definitely reach out to your legislators and talk about whether or not you think cash bail should be eliminated from the criminal justice system.
You've left me a little speechless. Okay. Okay. I was not aware of that. You have shocked the host. Congratulations. This seems like a good point to bring this up. There was or is a guy who's kicking around whose name is runs deep in the legal system here, and who has been released over and over again, and in fact has over 80 cases filed against him. How does that happen? Where is the disconnect there? Is this still the legislature making laws that just allow this guy to keep kind of popping out? Because it's got to be, I can't imagine, but it's got to be heartbreaking to the guys in blue that have to deal with this guy.
Yeah, I frequently hear frustrations from law enforcement all over the county about people being released continually on conditions of release. And here is where I think it becomes a judicial question, because the judge on the bench gets to interpret the law, interpret the case, interpret the arguments that are made. And I can tell you that very, very, very frequently, my office, when faced with someone who, from your example, has a large number of violating conditions of release, we try to make the common sense argument, Judge, this person doesn't follow your orders, so how can you be sure this person will come to court? So therefore, there's a risk this person won't come to court. That's what we're stuck arguing. And we make that argument frequently. We think it's a common sense argument, and that's why we make it, but we're not always on the prevailing side of that. And there are judges who will release defendants over and over and over on the same conditions with the hope, I guess, that they will at some point start complying.
Interesting. Okay. Yeah. So we had a chance to chat a little bit, and I sometimes I make statements that most everybody will understand. And I think that my statement is true. If you feel emotional about something, if you feel logical about something that's happening in the legal system, there is no way to attach those two things, because logic and reason have no place in the legal system, it would seem. Is that a fair statement?
I like to think of it as sometimes common sense goes out the window, which is why I enjoy doing jury trials. The jury instructions on all cases and my arguments to juries are use your common sense. But like the example of bail, emotionally, logically, commonsensically, you might think that bail is intended to stop someone from committing crimes and to put an end to someone being dangerous. That's not in the legal system here in Vermont what bail is for.
Okay. Well, I mean, you've explained that a $200 bail for an assault seems really, really low. And I think I had another question here about conditions of release. Is it a judicial thing or a legislative thing? I think we now know it seems to be more leaning towards our lawmakers and legislators. So even when you see a judge releasing somebody, they are just acting on the laws that are given. Can you unpack that a little bit more for us so that we understand?
Sure. The law does provide some guidance to judges. And again, the law is what the legislature creates for us. And it provides a little bit of some guideposts, if you will, for judges deciding whether or not conditions should even be put in place. It asks the judge to look at the person's history, the person's criminal history, whether they have a residence that's local, what their ties are to the community, and things like that. So those are the guideposts that the legislature creates. Judges are individuals and they interpret them differently in different situations, but the legislature sets out those guideposts, sets out that $200 limit, sets out also, just to be clear, the rare exceptions where people are held without bail are the dangerous felony assaults and the dangerous cases where we are worried about conditions of release not protecting the public. But again, those are felonies and they're particular kinds of cases. So yes, it's on the legislature to come up with these laws and consider what is appropriate for bail, what is appropriate for conditions of release.
Okay. All right. What can we do? How can the state and the county, how can we improve this so that we seem to have less and less of these kind of released on conditions things happening? There's, I guess, I'm not like an incarcerate guy. I don't think anybody is. I mean, it just doesn't seem to serve. So, and I think if somebody just kind of messes up once, then that's okay. And then but I don't think that these are the people we're talking about. But how do we improve that? Like eliminating bail altogether. Like, I'm not a fan.
Well, that's definitely something you want to talk to your legislators about. And I have said this also a number of times in a number of different forums. And, here I am going to age myself. So I've been doing this for almost 25 years. And when I started out, conditions of release were different. So when I started out, we had enough law enforcement that, for example, we would send folks every day to the police department to do an Alka-Sensor to see if they were abiding by their conditions to not drink.
Wow.
We don't do that anymore.
No.
And the police certainly don't have the resources or the personnel to monitor things like that. But the federal system, when people are released on conditions, they have people who can monitor defendants who are released. We just don't have the resources anymore in our local police departments. So what can people do? They can talk to their legislature. They can encourage the select board in funding the police departments that serve them.
Okay. One of those things I can help you with. Tracy, I've picked up a lot of this. I wanted to have this conversation with you. Thank you for coming in to do this. Is there anything that you feel like we need to cover before we go?
I just want to encourage folks to speak up. I think that when there is a good, healthy dialogue with differing viewpoints that are expressed, and I've been seeing that in the select board meetings more recently, people should speak up and people should express how they are feeling and what they are noticing in this county and what they want to see done about it. So it's not just one voice in the room.
Tracy, again, thank you for jumping on Vermontitude. That is Tracy Schreiber. She is the Windham County State's Attorney, doing a good job. Thank you.
Thank you very much.
Take care.